Me?
I send things to you all the time. I get bounced back. Yeah, I just saw it this morning. I sent it to Lopez, not one of them. No. I mean, that should work. Well, because maybe I use the right one sometimes. Thanks for noticing. Hey, how are you? That could have been, I would say could have been anyway, but no, it really could have been you. Hey, nice to see you. Yeah, it comes up. I must use that. Thanks for sending me things.
I feel like it's so lovely. I could be beating. I told you it was great. I didn't know anything.
No, I still distribute it.
So I didn't know.
Never been back. Well, I'm thinking, how people are running around running on this. Oh, that's nice.
Oh my God. Because you would be the first
Is your older daughter still? This year. Elsewhere for writing and
The deal is
yeah, this is real history. Did you enjoy the program?
Yeah, she's working real hard.
Hi, nice to meet you. Yeah, likewise. Yeah, I've been really interested in hearing what you have to say. I'd love to talk to you more.
Good afternoon, everyone. Welcome. Thank you so much for coming. My name is Chris Cervanek. I am the Associate Director at the Center for Civil and Human Rights. And this is the last lunchtime presentation we've organized for the academic year. And so I'm really pleased that it is focused on this most important and urgent topic. So today's talk is by Notre Dame Law School Professor Alexandra Levy. It's entitled Guilty Victims of Human Trafficking. Professor Levy teaches the course Human Trafficking here at the law school, which was very well received. She taught it for the first time in the fall. Will you teach it again in the spring?
Yes.
So for those of you who don't have to graduate and get to stay on, please consider taking this class. I've heard great things about it. And she is a graduate of the University of Chicago Law School. Professor Levy is an attorney at the Human Trafficking Pro Bono Legal Center, and she regularly speaks on a variety of topics related to human trafficking litigation and curates resources used by attorneys handling trafficking matters nationwide. Her compilation of cases brought under the civil provision of the 2003 Trafficking Victims Protection Reauthorization Act is a resource widely used by advocates and attorneys. We are most fortunate to have her here at Notre Dame Law School and as part of the Notre Dame community working on issues of human trafficking. So please join me in welcoming Professor Levy.
Thank you so much, Chris. Are these your glasses, by the way? Thank you for coming. Can everyone hear me? Okay. So, the term human trafficking brings to mind a clear story. It involves bad guys and good guys. Traffickers, we have a strong sense in the common narrative, they're sophisticated and manipulative and sexual and greedy. Right? And victims are young and virginal and vulnerable and manipulable and just cruelly exploited. In many ways, human trafficking looks like the last refuge of moral clarity. And it follows from this that the fight against human trafficking can take the tone of a morality play, right? A successful anti-trafficking campaign is the triumph of good, capital G, over evil, capital E. That's certainly the way the issue is rendered in the media. And this expectation of clarity has become so entrenched in the public discourse that to tell a different story invites a certain amount of alarm. But what I want to do today is to tell that different story. I want to take a closer look at the modern fight against human trafficking. Look at what it really is. Who's really involved? And I want to challenge some common assumptions. I want to do this for two reasons. The first reason is because there's significant censorship around some of the biggest, most important questions regarding human trafficking. I want you to try an experiment later today. Really, do it. Later today, ask one of your friends who's not at the lecture, why is human trafficking a problem? You'll probably be met with a fair amount of disgust and horror just for asking the question, but you probably also won't get a very good answer. Because the fact is, in our quest to turn human trafficking into a morally clear narrative, in our attraction to its more cinematic aspects, we've lost our ability to articulate the reasons it's a problem. It's just so obvious, right? Let me tell you, 200 years ago, it was also just so obvious, but in the other direction. And in fact, many of the same moral and religious arguments that we now trumpet as the bedrock of our anti-trafficking work also provided very strong foundations for another kind of trafficking work, and for the historically ubiquitous trafficking laws that regulated the purchase and sale of human chattel. And the thing is, trafficking is terrible, but it doesn't take away from its terribleness, and it certainly doesn't take away from our humanity and compassion for us to articulate why it's terrible, or on a more practical level, to figure out how to quantify its negative effects. The modern trend is to treat human trafficking as an unspeakable evil, involving morally polarized actors and unquantifiable consequences. But what I want to suggest to you is that that's the easy way out. After all, the more grandiose the battle, the less we actually have to get our hands dirty. But if we want to stop human trafficking, we need to get to work finding the words, getting to know the victims, and figuring out how to properly compensate them. The first step here is to recognize human trafficking as a form of theft. Human trafficking usually folds in many crimes: assault, rape, kidnapping, false imprisonment, to name a few. But in a significant way, it's its own creature. And what distinguishes it from these other violations is its commercial nature. At its core, human trafficking is a kind of commerce we want to prevent and punish, and a significant part of the harm it does to its victims is financial. The second reason I want to tell this alternate story is because facts matter. Antecedent to any successful effort to shape human behavior, in this case to deter traffickers and to help victims, is the need to learn who you're actually dealing with. And the fact is, very few trafficking scenarios actually involve flailing virgins and conniving evil men. But if we let ourselves expect that, if we let our advocates and judges and reading public become convinced that the relevant actors are going to look and act a certain way, we can't realistically hope that they'll know what to do when an entirely different set of characters walks into the courtroom or onto the page or into the story. And so for that reason, I want to look extra hard today at who is involved in human trafficking and what it would really mean to protect or defend human trafficking victims, which is in theory the goal of us anti-trafficking advocates. But to determine who the victims really are, we need to start by doing something uncomfortable. We need to put ourselves in the shoes of traffickers. Contemplating who we as bystanders, as academics, think of as vulnerable, that's academic. To make real headway, we need to identify who out there is actually most vulnerable to exploitation. And one important answer to this is that some of the easiest people to exploit are those who don't have the law on their side. And indeed, we see this again and again and again. A kind of vulnerability that many traffickers take advantage of. That is to say, a key characteristic they look for in potential victims is a person's alienation from law enforcement. And who is more alienated from law enforcement than criminals? Far from being paragons of mythic innocence, human trafficking victims are often victimized because they are guilty. Indeed, a close look at legislative history will show that some of the earliest anti-human trafficking laws arose as a way of protecting people who were vulnerable to having the law turned against them. The term human trafficking didn't enter the legal lexicon until just over a decade ago, in the year 2000, and by that point, the term carried the imprimatur of several hundred years of history. One thing those centuries show us is that the relevant players have long blurred moral lines. Trafficking victims, as contemplated under our country's laws, have rarely fit the profile we see in the movies or in our limited cultural imagination. And modern laws tell a similar story. People vulnerable to being trafficked are not necessarily weak or naive or blameless, but are often vulnerable because they have run afoul of other laws and can't seek their shelter. But of course, the text of the law doesn't tell the full story. I also want to give you some real-world examples. The way things play out on the ground is complex and spastic. When we expect simple moral contours, their absence can be jarring. We, the public, academics, judicial actors, tend to get paralyzed by unexpected facts, and that paralysis can get in the way of effective advocacy. Finally, I want to talk about what it means on a systemic level for human trafficking laws to be aimed at guilty victims. I'll argue to you that it's more than just a matter of extending legal protections to a commonly neglected group. Rather, modern trafficking laws might be the first and most powerful tool we have to productively regulate labor conditions in black markets. So, when the Trafficking Victims Protection Act was enacted in 2000, it didn't really criminalize anything new. Okay? Owning and exploiting and confining people, stealing their labor, all that had been illegal in one form or another for a while. What was new, though, was this term trafficking, along with an explicit recognition that some pretty complicated relationships that didn't necessarily include physical force or violence, could lead to involuntary servitude. Now, the TVPA was enacted primarily in response to two things. And the first was a case from 1988 called U.S. v. Kosminski. In Kosminski, the defendants forced two mentally disabled men to work on a farm. And they did this by keeping them as, to quote the Supreme Court, psychological hostages, by threatening them with institutionalization, by brainwashing them. The defendants appealed their conviction, and the case made its way all the way up to the Supreme Court. And the Supreme Court reversed the conviction, holding that the lower court had used an overly broad definition of involuntary servitude. O'Connor wrote this opinion. She said that allowing such a broad definition could lead to a slippery slope, where all kinds of relationships could be deemed trafficking. For example, she said, the statute could be used to punish a parent who coerced an adult son or daughter into working in the family business by threatening withdrawal of affection. Or how about a political leader who uses charisma to induce others to work without pay, or a religious leader who obtains personal services by means of religious indoctrination? But then 12 years later, when Congress enacted the TVPA, it specifically mentioned the holding in Kosminski as a reason for enacting this new legislation, and it stated its intention to have the new law cover Kosminski-like situations. In short, the TVPA acknowledged that traffickers don't always look like boogeymen. Victims aren't always tied up and beaten. Traffickers can just be very effective emotional manipulators, or individuals who know how to take advantage of one specific victim's specific weaknesses. The TVPA eliminated a one-size-fits-all approach to trafficking, under which only a narrow set of circumstances constituted trafficking under the law. As of 2000, trafficking includes all kinds of subtle power dynamics that might work against one victim, but not another. Let's go back. What was the fundamental trafficking relationship before this complexity was acknowledged? Laws addressing various aspects or type of slavery, laws that laid the groundwork for the TVPA, date back long before the 13th Amendment. Indeed, laws originally designed to regulate the slave trade, not to prohibit it, still make an appearance in the U.S. Code, where, for example, you're prohibited from procuring any person from any foreign kingdom to be transported and held, sold, or otherwise disposed of as a slave. That's still there, 18 U.S.C. 1952. Right then, or a little bit later, right around the time of the 13th Amendment, Congress enacted the Anti-Peonage Act. And this too directly contributed to the language of our modern laws. That's where the Kosminski court turned to define involuntary servitude. Okay? Define it as a condition of servitude, this is a quote, in which the victim is forced to work for the defendant, listen carefully, by the use or threat of physical restraint or physical injury, or by the use or threat of coercion through law or the legal process. Let's look at this. Well, we know what the use or threat of physical restraint or physical injury means, right? You can't physically coerce someone to work for you. No surprises there. But what about the use or threat of coercion through law or the legal process? Well, what this means essentially is that you can't enlist the state to help you force someone to work. First and foremost, states can't enact statutes that criminalize not working. Let's look at an early case. Back in 1911, in a case called Bailey versus Alabama, the Supreme Court struck down a statute that essentially made it a crime to breach an employment contract. The court held that to expose a person to the possibility of criminal punishment for not working amounted to using the law or legal process to force the person to work, which in turn constituted peonage and violated the 13th Amendment. The court said the state could not avail itself of the sanction of the criminal law to supply compulsion to enforce labor any more than it could use or authorize the use of physical force. This seems pretty straightforward, but let's look at it from another angle. Many peonage cases involved, and to this day involve, a situation where one person, let's call her Violet, borrowed money from someone else. And let's call him Bill. Violet, not having any assets, guarantees her loan by promising to work for Bill until her debt is repaid. Okay, so here we have Violet, who owes Bill, let's say, $1,000. And forgetting the terms of the repayment for a moment, if Violet simply deserts Bill, runs off with her money, she's unquestionably embezzled $1,000. Right? And embezzlement is unquestionably a crime. And in a direct sense, for Violet to stop working for Bill amounts to her stealing the $1,000. And yet the court said that it's unconstitutional. It violates the 13th Amendment for a state to make it a crime for Violet to stop working for Bill. The state cannot enable Bill to use criminal law to make Violet work for him. He can't even do this if she owes him money that she promised to repay by working for him. So what does this tell us about early forms of trafficking? Who are the players involved? Well, Bill is a lender, Violet's a borrower. Violet, by not working, is shirking on her debt. Okay? Violet's not really a good guy. But what the state is doing with this early anti-trafficking law is, in some sense, protecting Violet's right to act dishonestly. Now, Bill, of course, is not without recourse. He can certainly sue Violet for the amount that she owes him. But what we see here is that a key predecessor and a bedrock of modern anti-trafficking laws is this law that ensures that breach of contract actions remain firmly the purview of civil courts. This is a law that is designed to protect, indeed, a law that could only possibly protect individuals who are breaching a contract. In other words, individuals who aren't innocent. And this plays out in another way. Not only can the state not enact laws that force Violet to work for Bill, Bill can't use any criminal law to force Violet to work. He can't threaten to turn her over to law enforcement for an entirely different crime she committed if she doesn't work. Now you might be thinking, well, yeah, of course he can't, that's blackmail. But what's amazing here, that's not just blackmail, that's human trafficking. Who's being trafficked? Violet. Who's Violet? Violet's a criminal. I want to go back and put this in context. Anti-peonage laws still exist today. But remember that they were enacted long before the TVPA recognized subtle dynamics could comprise trafficking. Nowadays, it's pretty intuitive to us that coercion doesn't have to be physical to be real. But these laws were enacted at a time when psychological manipulation wasn't recognized as a tool of coercion. If you weren't physically forced to work, you weren't being trafficked. Unless, that is, you were being forced to work at risk of being exposed to criminal liability, either for not working, for breaching a contract, or for doing something else, in the case where Bill threatens to turn Violet in for car theft, whatever other crime she committed. In an era where Congress and courts primarily construed the word force to mean a physical, concrete, literal thing, they also recognized that a person could be forced through threat of exposure to legal liability. Now, why in an era when psychological coercion didn't count did Congress single out this one single kind of non-physical coercion? The simple answer is this: because Congress realized that this was an overwhelmingly popular and effective way of enslaving people. The problem that Congress was seeking to fix, involuntary servitude, was sometimes accomplished through physical force, but was also commonly enabled by abuse of law or legal process. Congress was responding to the fact that lots of people were being forced to involuntarily serve. They were being turned into slaves, or in modern language, trafficked, by people who turned the law against them, one way or another. We can glean something pretty significant from this. The anti-peonage statutes were particularly well suited to address problems that arise when one person has the law on his side and a second person does not. The anti-peonage statutes were very important to people vulnerable to having the law lorded over them. They mattered to people who were worried about the law or legal process being turned against them. They mattered to people who were guilty, or who could easily be convinced that they were guilty of a crime. So before 2000, there were essentially two scenarios that counted as trafficking. The first was when one person physically restrained another. That's straightforward. But the other scenario is when one person uses the law against another. And when is that a possibility? Well, a threat of criminal consequences is only effective against an individual who believes, or who can be led to believe, that he would be subject to punishment under the law. The fact that such threats were included in the initial, most basic definition of force show that anti-trafficking laws have long recognized the particular vulnerability of people who have committed, or who believe they have committed, crimes. As I mentioned, the TVPA, enacted in 2000, was largely a response to two things. Partly U.S. v. Kosminski, but it also answered a call to protect international trafficking victims. Up until 2000, most, not all, but most anti-slavery peonage statutes involved domestic victims here in the U.S., and they were mostly targeted at traffickers of citizens. The TVPA, on the other hand, set its sights on some of the particular plights of foreign victims. It did this by focusing on some of the liabilities and challenges of being not just an immigrant, but an undocumented immigrant. The most notable way in which the TVPA accommodated undocumented aliens is through something called the T visa. The T visa is a temporary visa and a path to citizenship that allows trafficking victims in the U.S. to stay here, provided they cooperate with law enforcement's efforts to apprehend and prosecute their traffickers. Now, this obviously is only meaningful to non-citizens who don't have stable immigration status. Victims whose immigration status was once legal but has lapsed are able to make use, but maybe more notably, so are victims who were in this country illegally to begin with. Protections offered to illegal immigrants are just one demonstration of the fact that in enacting the TVPA, Congress recognized this key vulnerability of trafficking victims of their illegality. Indeed, the TVPA goes further than just providing relief for illegal immigrants, and we'll see this through a close look at the restitution provision of the TVPA. Restitution is mandatory under the TVPA. That means that someone convicted of trafficking has to compensate his victim. The mandatory restitution provision recognizes that trafficking victims are owed two kinds of restitution. The first kind is pretty straightforward, and the language is borrowed from the mandatory restitution statute for other kinds of abuse. It includes full amount of victims' losses, including medical care, occupational therapy, lost income, attorney's fees, that sort of thing. And this makes sense. It makes sense because trafficking is inherently abusive, so victims are entitled to recover for the kinds of losses victims of violence generally suffer. But the thing about trafficking is it's also an economic crime. What distinguishes trafficking from garden variety assaults, kidnapping, rape, imprisonment is the fact that the trafficker benefits financially from the crime, that the trafficker has stolen something of monetary value from the victim, namely his labor. So it follows that trafficking victims are entitled to a second kind of restitution for what was stolen. And the TVPA addresses this too by entitling victims to direct compensation for the work they unwillingly performed. Now, in order to understand how we calculate that, you need to know a little bit about the kinds of cases we see prosecuted. Trafficking prosecutions can pretty neatly be divided into two kinds: labor trafficking and sex trafficking. The most important distinction between these two for our purposes is the legality of the labor involved. In labor trafficking cases, the work, if performed voluntarily, would be legal. For example, migrant labor, domestic labor, for that matter being a lawyer or a doctor. Sex trafficking, on the other hand, involves labor that has no above-ground market. And this is very meaningful. Whether the work could be legal or not is critical for purposes of calculating what restitution is owed to the victim. Going back to the restitution provision, we see two options for how to calculate the amount owed. Victims are entitled to the greater of the gross income or value to the defendant of the victim's services or labor, or the value of the victim's labor as guaranteed under the minimum wage and overtime guarantees of the Fair Labor Standards Act. I'm going to start with the second option, the minimum wage and overtime guarantees of the Fair Labor Standards Act. The FLSA is the cornerstone of labor protections, ranging from minimum wage to overtime pay. Giving a victim restitution in the amount guaranteed by the FLSA is a very straightforward way of compensating them for labor performed. When it comes to legal kinds of labor, that is labor that if performed voluntarily has a place in the open market, this is an easy way of calculating damages. And what you see in court is experts from the Department of Labor with spreadsheets and wage and hour calculations. You multiply minimum wage by number of hours worked, and you get an amount. But there's a significant limitation. The FLSA only applies to legal work. So when restitution statute talks about the minimum wage and overtime guarantees of the FLSA, it's only talking about labor that can be performed legally. And most trafficking prosecutions involve work that's not only coerced, but illegal to begin with: commercial sex. Commercial sex, even when performed voluntarily, is illegal, and that means it has no value under the FLSA. So we're faced with a conundrum. We want to compensate trafficking victims for what's been stolen from them, but what if that thing is illegal to begin with? Going back to Bill and Violet, let's say Bill has trafficked Violet for sex. That means he's stolen Violet's illegal labor. Our job is to figure out how to compensate Violet, who's both a trafficking victim and, technically speaking, a criminal. The easiest and maybe most intuitive answer would be just to say that Violet is entitled to restitution, of course, for her personal losses, for pain and suffering, the same way any victim of violence would be. But that's it. Because there was no legally protected economic interest at stake. There was nothing legal for Bill to steal. But that's not what we see in the TVPA. The TVPA entitles trafficking victims to restitution not only on par with restitution owed to other victims of violence, that's the part that's cross-referenced with the other restitution statute, but also entitles them to the market value of their work, even if that work is illegal. And here we face another conundrum. How do we determine the value of illegal work? The FLSA isn't helpful, but the TVPA offers an alternate metric for quantifying stolen labor, one that applies to illegal and legal work alike, and that is the value to the defendant of the victim's services or labor. By including that clause, Congress gave sex trafficking victims an economic interest in their labor. That seems right. But what's amazing about this is that it's an economic interest that disappears if the work is done voluntarily. Let's go back to Bill and Violet again and imagine two different scenarios. In the first, Violet is performing sex work voluntarily. Bill is Violet's broker. And let's say that customers pay $50 an hour for commercial sex with Violet, but the arrangement that Bill and Violet have is outrageously favorable to Bill. Violet only takes home $6.50 an hour. That's below minimum wage. Bill takes the rest. Can Violet recover what she's owed under the FLSA? Is the Department of Labor going to sue Bill on Violet's behalf? Are criminal charges going to be brought against Bill for underpaying Violet? No, of course not. Violet's work is illegal. She doesn't have labor rights. Let's look at a slightly different scenario. Same facts, but this time Violet isn't in it voluntarily. In fact, this time Bill is trafficking Violet. That is to say, he's forcing her to perform commercial sex acts through the use of force, fraud, or coercion. But let's say the arrangement is otherwise the same. Customers pay $50 an hour, and Violet gets to keep $6.50 an hour. And then Bill gets caught and convicted of sex trafficking. What can Violet recover this time? Well, Violet can recover everything Bill earned from her labor. She can recover $50 an hour, the market price for her illegal labor. This is all to say that while voluntary prostitution has no legally protected economic value as a form of labor, i.e. it's not included in the protections of the FLSA, involuntary prostitution, sex trafficking, does have a legally protected economic value, and that value is what determines the amount that victims are owed in restitution. The TVPA makes it possible for what is in one context a criminal act to be, in another context, compensable labor. Put differently, the TVPA makes it possible for what is, in one context, a criminal to be, in another context, a victim worthy of protection. So what does this all mean? We now know that the TVPA does some work to reconcile victimhood and criminality, and that this has the arguably positive effect of giving more people, including guilty people, access to justice. What does this mean on a systemic level? Let's go back to the Fair Labor Standards Act for a moment. The Fair Labor Standards Act was passed in 1938. It's the cornerstone of many labor protections we have today. The fact that labor conditions are regulated is something we really take for granted. And in fact, we often view other countries' labor protections as a kind of barometer for how civilized or humane or progressive they are. But while touting the importance of our labor regulations, and here I'm talking about the bare minimum, nothing that comes close to any political controversy, we're all too willing to accept that they only apply in legal markets. And we're outraged when we hear that employers forbid children working in sweatshops in Southeast Asia from going to school. But when we hear the same about those employing children to sell cocaine in Chicago's South Side, our first or second or even 10th thought isn't, we really need to enforce labor laws in that market. But why should labor laws be contingent on the legality of the underlying work? The practical answer, or non-answer really, is it's often redundant to try to regulate labor conditions in illegal markets. When a drug kingpin is arrested, charging him with underpaying his workers will likely pale in comparison to whatever other charges he's facing. But this isn't a complete answer. The costs and benefits of making or keeping a product illegal arise in two ways. First, there's the question of the thing itself. What issues might arise from having more of this thing around? To stick with our example, what are the costs and benefits of legalizing drugs? But the inquiry doesn't stop there. The question of whether to make or keep something illegal also has to take into account the effects that a black market for that thing has. The question isn't, do we want drugs to exist or not? But rather, do we want drugs to exist on the legal market or on the black market? Is more addiction worth the number of lives saved in the Mexican drug wars or not? There are many factors to be weighed, and ultimately the question becomes unwieldy, whether you're talking about drugs, guns, or sex. But what if we could evaluate some of the important problems of the illegal market separately from the problems with the product itself? I'd like to suggest that the TVPA gives us exactly this opportunity. By disentangling legality and restitution, the TVPA gives us a foothold into regulating labor conditions in illegal markets. It disaggregates the question of whether it should be legal to sell drugs from the question of whether it should be legal for those selling drugs to inflict labor abuses. And by doing so, it provides an exceptionally powerful tool for safeguarding human rights. But we can only use this tool effectively once we stop insisting that victims fit a certain mold of innocence and naivety. Now that we've looked at the reality of what trafficking involves, who it involves, what kind of manipulation it might entail, I want to turn to how this plays out on the ground, and that is to say in courts. The fact is that while we as a society are very adamant that trafficking is bad in the abstract, we're ambivalent about protecting victims who aren't as we wish them to be. That is to say, we're often less than willing to actually protect victims who are guilty. This dilemma frequently unfolds during restitution hearings in criminal trafficking cases. Many courts have expressed a sentiment similar to that voiced by the judge in a case called U.S. v. Lopez-Perez, where the judge said simply, "I wonder how it would be an appropriate measure of loss, the money that was made from engaging in an illegal activity." The prosecutor was successful in Lopez-Perez. The fact is that restitution is mandatory, so this should not be a hard case to make. But the alarming thing is restitution awards are far from ubiquitous. Instead, what we see play out again and again is a recurring struggle to accept that trafficking victims who have committed a crime are entitled to the proceeds from that crime. Cases come out in different ways, but what's remarkable in and of itself is how frequently the issue is grappled with, discussed, agonized over, given that restitution is mandatory under the statute. In courtrooms across the country, defense attorneys are taken seriously when they argue that to pay sex trafficking victims the market price for prostitution would be, quote, a windfall. That they're even asking for restitution is opportunistic. Even highly experienced prosecutors have expressed surprise that the appropriate measure of damages is ill-gotten gains. Maybe the most vivid example and one of the most revealing outcomes was in a recent case out of Texas called U.S. v. Rojas. In Rojas, the defendants were convicted of trafficking several children and adult women. Notwithstanding the fact that the defendants were guilty of trafficking all of the individuals, and that by extension, all of the individuals were trafficking victims, the court only awarded restitution to the children. The judge reasoned that even if the adults were forced, they weren't owed restitution because they were, quote, furnishing the facility, which is still illegal. Later in the proceeding, that same judge conceded that he had to give restitution to the minors, despite the fact that he noted multiple times they were violating American labor laws. He said, in perhaps a moment of real honesty, "I understand. It's adults I can't stand. Children I have some concern for." This judge's words may shock us, they should shock us, but if we look closely, all he's done is given voice to a larger conversation that's taking place in courtrooms, in classrooms, newspapers, everywhere. In that conversation, we're all struggling to reconcile the characters we expect, innocent children, bad men, with the people we see in front of us. Some innocent, but many guilty, and many vulnerable because they're guilty. What I want to leave you with today is this. The real fight against human trafficking requires us to stop letting that incongruity paralyze us. Anti-trafficking work is not, in fact, a cinematic or heroic quest. And until we stop sacrificing the facts at the altar of moral clarity, we are depriving ourselves of our most powerful tools for fighting trafficking. What anti-trafficking advocacy is a quest to protect all people, even, especially, when they're participating in illegal markets. Put to good use, anti-trafficking laws equip us to do something incredible, something I think more spectacular than any morality play. They give us the opportunity to bring human rights to black markets. I'd suggest we start putting those laws to good use. Thank you. Questions?
Yes, we have about 20 minutes. So
20 minutes, awesome.
we can take them from the podium.
Yes.
In these cases where, I don't know much about this field, in these cases where they're hesitant to give restitution, is it mostly sex trafficking cases? I'm wondering what other kind of work these victims would be doing that is illegal, or if it's mostly just sex work.
So I think that's a great question. The only kind of illegal work we have seen in the criminal cases is sex. I would love to see cases with drugs, drug sales, and I think that actually as we develop our understanding of the real nature of victims, we'll be able to do that more. But I think there's so much hesitation even with the sex cases because the underlying work is illegal that so far they haven't pushed those boundaries. Yes.
Great presentation, thank you very much. I'm curious about the genesis of the disparity between the conventional narrative and the narrative that you're presenting. Is it something you can speculate about? Is it a story that sort of fits a narrative that we expect to hear and that advocacy organizations can use to their benefit because it makes us all feel good, or is it a narrative that originated overseas where perhaps it's more accurate and then sort of has been subsumed domestically? And then secondly, I'd just be curious to know if you have if there's any empirical work that's ever been done that's tried to sort of get at I know this is a reductive question, but the number of cases of trafficking that sort of look like this traditional model and the ones that look more like the model that you're describing.
So the answer to your first question could take about 6 days to answer. It's a great question, and it's something that I wish more people would ask, because the fact is that the narrative, the genesis of the narrative really tells us a lot. My short and somewhat cynical, but I think reality-based answer is this. Trafficking has obviously been a problem for a long time. For most of human history, it's been legal, right? And then for about 150 years, it's been illegal. And no one really paid a lot of attention until the 90s. What happened in the 90s was the collapse of the Soviet bloc and a lot of white women being trafficked across international borders. Basically, when Westerners and Americans saw white women as opposed to brown men and brown women, they started to pay attention. And so the narrative took hold. And now, thankfully, I think that the application of the law is not exclusively to protect white people. So it's expanded a bit, but I think that's the genesis of the narrative. I think it's very racist. Your second question, the empirical work. I'm doing empirical work. I like empirical work. I don't know if you can tell from the presentation. I think this field needs to be more rigorous, more data-based. One thing that I've been trying to do is sort of quantify what does it mean to be in one narrative versus another. And in a lot of the sex cases, most of the sex cases, first of all, most prosecutions are sex cases instead of labor, and most sex cases are of children, trafficking of children. So I've been sort of looking at, well, what could be indicators of guilt, quote unquote guilt. And some things that I've looked at are illegal status, immigration status, and also if the person entered the trade voluntarily. Those things might, in fact, sort of damn that person with respect to getting restitution. But I think it's a great question to explore. Yeah.
So, I guess I would sort of advance a counter argument to your narrative in the sense that maybe it's a dishonest narrative if you really look at the victims, or it can in certain circumstances be a dishonest narrative. But I think that it engaged public outrage because it was this, minor innocent person being trafficked. And it mobilized people, and you got the Palermo Protocol, and you got all these countries enacting anti-trafficking laws. And so in a sense, I don't think that's a bad thing. And I agree with you that yes, when you're confronted with the reality and you have to deal with it, and courts have to apportion damages, and then it might become sort of complicated and uncomfortable. But I don't necessarily think it's a bad thing, because I do actually think there are a lot of innocent victims out there, who are trafficked and who do conform to the narrative. And then the second thing that I would say also is that I really liked your presentation, but in some senses I think, and maybe you didn't have a chance there, to think about the sort of anti-trafficking thing that you mentioned a moment ago with Eastern Europe, and these Eastern European women being trafficked. That the United States wasn't just operating and enacting laws in isolation. The United States has been really active internationally in getting other countries, and in the TIP report and in the Palermo Protocol and things like that. So the TVPA didn't come out of a vacuum. It came out of the whole international movement against trafficking. And I think that that's important, that it wasn't just our narrative, it was a communal narrative as well, that's also been in existence since 1900 or 1909. So.
Yeah, I think you bring up important points. I think with respect to the first one, I think it's an important question in general in any kind of work. To what extent are we galvanized to do more, and to what extent are we placated by the outrage of others and sort of international attention? I know a lot of people who are very outraged about human trafficking and who love to feel that outrage. I mean, this is, in fact, something that's not controversial in sort of public discourse, and it shouldn't be, right? It is unequivocally bad, but you get a lot of scenarios where advocates, in quotes really, sit around and talk about how terrible it is, and they don't do anything. And the fact is that if we let them do that, we kind of give them a pass. On the other hand, as you pointed out, galvanizing some kind of awareness is a good thing. So I think it's a balance there. Now, in terms of the TVPA arising in a vacuum or not, of course it didn't arise in a vacuum, and it was an answer to this international call. But it is pretty remarkable, I think, that people act like it's a new thing. People act like it's a new thing in the 90s when white people got involved as victims, I think. And maybe the added awareness is good, maybe it's not, but I think we really have to be cognizant of that fact. It's been going on internationally forever. That's not new. What is new is the race thing. Yeah.
I was wondering, because the definition of trafficking has expanded over the last decades and isn't the traditional, more narrow view that people thought that it was, how is the voluntariness factor decided of whether or not the worker is voluntary? Has that expanded as well? Or like what kind of considerations do prosecutors or courts ultimately decide led to whether the worker is voluntary or involuntary?
Great question. It's incredibly complicated, and as the court feared in Kosminski, it is kind of a slippery slope. I don't think it's gone too far. I don't think it's sort of panned out in the negative ways they expected, but to answer your question, it is particular to every situation. There are trafficking cases, civil cases at least, between a husband and wife. There are cases with religious leaders, people claiming to have been coerced by religious indoctrination. And prosecutors and juries are faced with this question of examining individual relationships to see whether in this particular case it was voluntary. So it is a tough thing to do. But I think it's worthwhile in order to have that expanded definition.
Maybe you could talk about trends that you may have seen in law enforcement when police are confronted with situations where 20 years ago they would have just assumed that it was all criminal activity and that was the end of it. How has this country at least addressed law enforcement's response to trafficking?
It's tough. There's a big push to recognize that many victims of sex trafficking, at least, are not primarily criminals, that they're victims of rape, and sort of to focus on that aspect. There's a new system, a new court system in New York that takes sex trafficking victims or alleged sex trafficking victims and sort of treats them differently than other criminals. And that gets into this incredibly thorny territory about whether prostitution is always sex trafficking, as some, I would say, a minority of people say, or whether it can be voluntary, when it's voluntary. And I think, to really answer your question, law enforcement has been trained to be more sensitive to that question. That doesn't really make the question a whole lot easier to answer. Is that helpful?
Yeah. I imagine they bring their own prejudices, and you hope that you can train those prejudices out of them to understand the complexities of the situations
Yeah,
they're facing.
absolutely. Yeah, there's they need to be trained as much as the rest of us, maybe more than the rest of us, to recognize how complicated it really is for victims who are criminals and criminals who are victims and that kind of thing. Yeah.
It seems to me that one of the ways that the conception of trafficking has expanded is that any time there is an underage case of prostitution, it's got to be trafficking because the person is not cognizant and so on. I'm very intrigued actually by what you talked about in the case of selling drugs, and whether, would it be appropriate to treat juveniles selling drugs as victims of trafficking, psychological coercion? Or would that be inappropriate? Would it open up more cans of worms than we want to?
So the juvenile adult distinction is relevant in sex trafficking. It's not so much relevant in labor trafficking. And what I think should happen is, I think these drug prosecutions should go on, but they're labor trafficking. So I'll do one
Right.
more, to go even farther and say, I think that we should start looking at voluntariness in adults who are participating in the drug markets. These black markets, especially the drug and guns as well, black markets are very violent. When you don't have the law, you need violence. And they are absolutely a place where we need labor rights enforced, more than anything. I think, so I think we should be paying attention to the adults too, for sure. Yeah.
If a trafficker is being prosecuted, does the victim then have to seek their own restitution through the civil courts? And if so, how are they able to access advocacy? And what's going on for victims after the criminal process is over?
So to answer your first question, they should get restitution just in the criminal process, right? That's what the mandatory restitution is. The prosecutor should seek it. They cannot be required to testify, anything like that. There is a civil system. That's where my work is, and my work is very much trying to get those victims access to lawyers who can bring those cases in civil courts, because it's tough. I mean, almost by definition, people who are trafficked don't know their rights. They certainly wouldn't expect excellent lawyers to want to stand up on their behalf. So I think the outreach efforts are largely the domain of NGOs and social services organizations, but you do see there are distinct populations that are more vulnerable than others. Domestic workers, for example, actually employees of diplomats, right? So things that are as simple as putting up flyers in different languages, that kind of thing, and making them aware that they can reach out. And at that point, it's also about getting the lawyers involved, but the fact is lawyers really want to be involved in that, which is great news. Yes.
I'm curious whether or not you've thought about trafficking in the context of slavery as an unconstitutional act, and is it right to bring this only under federal statutes, or is it also right to maybe bring these cases as constitutional rights against slavery?
Constitutional rights is distinct from federal cases.
No, I mean, you don't need federal statutes if you have a constitutional right against slavery, right?
Well, so the TVPA is the enabling statute of the 13th Amendment. So
Okay.
it's really, I think people have tried to bring it straight under the 13th Amendment. Of course, said, no, you gotta do it.
Okay. So it always does through the implementing legislation of this statute.
Right. And I should say that there are state statutes. All 50 states now have anti-trafficking statutes, so you're not stuck with the federal laws. They all mirror this, essentially. Yeah.
This feels like a question I should know the answer to, but is it legal in the United States to like secure a loan with your labor?
Yeah, but you can't actually collect the loan through the laborer.
Okay.
And it's tough because there are a lot of people who legitimately want to lend to people who legitimately don't have assets.
Yeah.
And that really hamstrings people who don't have access from getting loans because you can't enforce this kind of payback of the debt.
So if someone did that, they couldn't enforce. If they tried to enforce a contract like that, they would be trafficking.
Well, if they tried to.
I guess in the if they use that to I guess not necessarily enforce. If they enforce it like in a civil court, it might not be.
Yeah, well, you can sue for breach of contract for sure. You just can't. There's no crime of breaching that contract.
But are those contracts legal though? So they can be enforced in a civil court?
Sure, yeah.
Okay.
Yeah.
Thank you.
You're gonna ask someone one.
Because this person, so you say like you go in the house and you say and then he freaks out. You've got your cash.
Yeah, we actually met.